The Directory on the Ministry and Life of Priests, issued by the Congregation for the Clergy, summarize the underlying principles for the canonical disposition that we shall shortly take up. First, the priest, a servant of the universal church, cannot tie himself to any historical contingency and therefore must be above any political party. He cannot take an active role in political parties or labor unions unless, according to the judgment of the ecclesiastical authority, the rights of the church and the defense of the common good require it. Second, in fact, even if these political parties and labor unions are good things in themselves, they are nevertheless foreign to the clerical state, since they can constitute a grave danger of division in the ecclesial communion. Like Jesus, the priest ought to refrain from actively engaging himself in politics in order to be a central point of the spiritual fraternity. All the faithful, therefore, must be able to approach the priest without feeling inhibited for any reason. The priest will remember that it does not fall on the shoulders of the pastors of the church to intervene directly in political activities and in social organizations. The task forms part of the lay faithful's vocation, in which they work by their own initiative together with their fellow citizens. Nevertheless, he will not be absent in the effort to form in them an upright conscience. Now we go now to what Canon Law says about clerics assuming public office. The Canon Law categorically prohibits clerics to assume public office. This is contained in Canon 285, paragraph 3 of the Canon Law, and it states, clerics are forbidden to assume public offices which entail a participation in the exercise of civil power. The norm finds its doctrinal justification and the very nature of the ministerial priesthood and in the proper mission of the sacred ministers. Clerics are consecrated by a particular sacrament and sent through a canonical mission in order to be the dispensers of the mysteries of God. Four things, therefore, are to be considered in this provision of Canon Law 285, paragraph 3. Number 1, it is a norm of the universal law, thus obliging all priests of the Roman Catholic Church, whether secular or religious, and whatever the personal and social circumstances in which they may be exercising their ministry. Second, the prohibition extends to the exercise of all civil power in all its forms, that is, executive, legislative, or judicial. Third, it is an imperative norm, going much farther than a mere counsel or recommendation. This is clear not only from the categorical tenor of the canon, that is, clerics are forbidden, but also from the absence of any provision or consideration of the possibility of obtaining permission to act to the contrary, as in the cases of the other prohibitions. And so, we have here, without the permission of their ordinary, clerics are neither to become agents for goods belonging to lay persons or assume secular offices which entail an obligation to render accounts. Clerics are forbidden to conduct personally or through others business or trade, either for their own or that of others, without the permission of legitimate ecclesiastical authority. Clerics are not to have an active role in political parties and in the direction of labor unions unless the need to protect the rights of the church or to provide the common good requires it in the judgment of the competent ecclesiastical authority, And this is quoted directly from Canon 287, paragraph 2. But it has to be observed that this prohibition is not placed in a penal form. That is, there is no law specifically typifying the violation of the prohibition. A priest taking public office with public power as an ecclesiastical crime and specifying the punishment attached to it. This is indeed curious, since other prohibitions stated less taxatively are in fact typified as crimes. For example, clerics or religious who practice trade or business against the prescriptions of the canons are to be punished in accord with the seriousness of the office. Confer Canon 1392. The violation of this prohibition can be punished by ecclesiastical authority. Notwithstanding the absence of a specific penal law typifying the violation of the prohibition for clerics to assume public office as crime and attaching a penalty, the violation of this prohibition can be punished by singular precept or by judicial or administrative decree, according to Canon 1399, which states, I quote, "Besides the cases stated here or in other laws, an external violation of a divine or ecclesiastical law can be punished by just penalty only when the particular seriousness of the violation demands punishment and there is an urgent need to preclude or repair scandal." Canon 1399 is the ultimate recourse of the ecclesiastical authority in order to exercise with due cause the jus penandi, the right to inflict penal sanctions, which is part of the power of the jurisdiction of the Church. For the salus animarum, which does not exclude the good of the faithful, who is guilty of an action which is harmful both to himself and to the ecclesiastical community, the ordinary can impose a penalty on whoever persists to violate an ecclesiastical law in a serious way, despite due warning. As Canon 1311 declares, I quote, "The Church has an innate and proper right to coerce offending members of the Christian faithful by means of penal action, sanctions," unquote. And so there is a punishment for those who are engaging themselves in partisan politics. But this punishment lies now on the discretion of each individual diocesan bishops or the ordinary of the place.